Good afternoon, everyone, or good morning if you're watching from the Pacific time zone. I am, as always, Brian Festa. I am an attorney, a civil rights attorney, and co-founder and vice president of We The Patriots USA, WeThePatriotsUSA.org. We have that website right down there. I'm just letting someone know that we are live streaming, so this can be shared in various groups and platforms across socials and everywhere else. Today was a big day, and that's why I don't usually do live videos like this 2 days in a row, but today was a really big day, and I'm getting a lot of calls, a lot of messages from people asking what happened at the Second Circuit, what happened in the religious exemption case, is there a decision yet? No, the courts never issue decisions in these kinds of cases anyway, the same day. Very rarely will a court issue a decision immediately. Certain types of limited cases, types of hearings that may happen. There might be rulings from the bench, but generally in a case like this, you're talking about a case that's been working its way through the federal courts for 3 years now, and is finally at the Second Circuit. They will take their time to issue a decision. It could be a matter of just a month or two. It could be 6 months. We don't really know, but I'll talk about timing in a little bit. For those of you who don't know what we're talking about, this is the Milford Christian Church versus the state of Connecticut versus Beth Bye, the Office of Early Childhood Commissioner, in the case defending Milford Christian Church and their Little Eagles daycare and preschool that's owned by Milford Christian Church, because the state back in 2023 tried to actually shut that school completely down because they continued to honor religious exemptions even after the state had repealed the religious exemption, had abolished the religious exemption for school vaccinations. So any of you who are following, any of you who are watching from Connecticut, who are following what's been going on in the Connecticut legislature, particularly this session, but particularly this week, HB 5044, it's a House bill. It's been passed now through the House of Representatives in Connecticut. It's going to the Senate next for a vote, probably this week. And everybody's been watching that very, very closely because obviously that is a bill that directly, for those of you who are following it, it concerns vaccinations, vaccines in school, also potentially opening the door for vaccine mandates and requirements for adults. And they're trying to amend the Religious Freedom Restoration Act, the state law, the RFRA, as it's called. They're trying to amend that so that there's a carve out. So there's an exception. So everybody else in the state gets religious freedom except people who oppose school vaccines, who oppose vaccination for children in schools. There's going to be a carve out. Why? Well, the Attorney General asked for that carve out because they were losing a state court lawsuit, which was based on RFRA. And the court sent it back to be litigated in the trial court and Superior Court on the issue of the Religious Freedom Restoration Act. And the state would have to survive what's called strict scrutiny. The state would have to prove that there was a compelling state interest for them to remove the religious exemption for vaccines, and that they did so by the least restrictive means, which obviously we contend in this case they did not do. Now, some people are confused. They're saying, well, wait, this hearing, this is a coincidence. This is more than a coincidence. This hearing that you had at the Second Circuit is being held the same time they're trying to pass this law so quickly because the two are tied. Some people are confusing. No, this lawsuit today that was argued at the Second Circuit, the Milford Christian lawsuit, is a federal lawsuit. It has nothing to do with that state lawsuit, which I just referenced, which is based on RFRA, which is state law. Our lawsuit, We The Patriots USA's lawsuit that we're talking about today, that was argued at the Second Circuit today, is a federal lawsuit based on constitutional claims. And this is really, really important because even if this bill passes, and it's looking right now like it's going to, even if this bill passes in the Connecticut legislature and is signed into law by Governor Lamont, it'll have no impact on our federal lawsuit, on this federal lawsuit for Milford Christian, because the state can't write a law that doesn't end run around the Constitution. The state can't bypass the Constitution or overrule the Constitution. They can overrule their own laws. They can amend their own laws, which is what they're trying to do here in the case of RFRA, but they can't amend the Constitution. the U.S. Constitution is the U.S. Constitution. So if we win at the Second Circuit, it's not going to matter how many laws they pass in the legislature. We'll get the religious exemption back. That's our goal. That's what we're fighting for. If we have to go to the Supreme Court after this, we'll go to the Supreme Court. But we'll appeal anyway and try to get to the Supreme Court. But right now, we had a hearing today at the Second Circuit. My initial reaction, my initial thoughts, I wasn't the attorney who argued it. It was our brilliant attorney, Cameron Atkinson, who did a very fine job arguing before a panel of 3 judges at the Second Circuit this morning. I think it went very well. I listened to the entire thing live. I'll post a link to the archive in the description or on socials or both if I can across our socials. And I'll maybe even send out an email as well if you want to listen to it. I thought it went as well as it possibly could. These arguments at these circuit courts are very, very tough, especially in places like California, where we were last week arguing for a school religious exemption case at the Ninth Circuit. Literally just last Friday, a few days ago, we were at the Ninth Circuit. Cameron Atkinson, actually, the same attorney, was at the Ninth Circuit arguing for us in a case, the school religious exemption case in Pasadena, California. And then today, the following Wednesday, he's arguing in New York City before the Second Circuit. Very same issue, this time concerning the state of Connecticut's religious exemption repeal. We have a nationwide strategy here, We the Patriots USA. We're trying to win back religious exemptions in every circuit in the country where they've been lost. The Ninth Circuit, the Second Circuit, and we have a case we're working on right now in the First Circuit for Maine as well. And I'll talk about that when it comes out. But that could be and should be dropping this week. By the end of this week. So hopefully within the next couple of days, we'll have a big announcement about that case. We have a nationwide strategy. We want to win these back for everyone. But this case today was concerning Connecticut. And the judges seem to be open to the idea of, strict scrutiny could apply here. Because obviously we have the new precedent that I talked about yesterday, the Mahmoud v. Taylor case that was decided last year by the Supreme Court that said parents have a right to opt their children out of LGBTQ curriculum in schools. That was a Maryland case. And then the Mirabelli v. Bonta case that said parents have a right to know if a child is trying to transition to another gender in school. That's not something, California, this policy, no, keep it secret from the parents. No, parents who have a religious objection to this, who have a parental right to know what's happening with their child. And again, that case also, relying on Mahmoud, went in favor of the parents. So we have very solid precedent now. Things have changed. I talked about this yesterday. Since, a couple of years ago when we had a case before the Second Circuit to challenge Connecticut's religious exemption, that was another case, but we didn't have this Mahmoud precedent. We didn't have Mirabelli. The legal landscape has completely changed in the last couple of years. So it really just in the last year. Mahmoud was issued last June, not even a year ago, and Mirabelli just a few months ago. So maybe not even a couple months ago. So we're in new territory here. And the judges seem to recognize that. They were asking about, well, what happens if we apply strict scrutiny? What would be your response to that? They asked the state's attorney, Attorney Cunningham, and he didn't really have a good answer. He said, well, we would ask that you remand that back for proceedings because, I'm not really comfortable I don't really like addressing strict scrutiny at the motion to dismiss stage. He wants it to go back for a full trial if they decide strict scrutiny applies. We know the state isn't comfortable with that. That's why they went to the legislature to try to change the law, to try to change RFRA. And in fact, that's what I would say in response to that. Can the state prove strict scrutiny? Is the state confident it can withstand strict scrutiny and prove that there was a compelling interest that was achieved by the least restrictive means possible? No. In fact, Attorney Atkinson this morning for us laid out 8 to 10 different things that the state could have done. Some of them better than others, but still better than completely excluding all students who have religious exemption from school. There are lots of different things. He went through a list, one by one, all the things the state could have done. It was brilliant. And the judges picked up on that when they went to Attorney Cunningham. They said, well, what about the 8 to 10 things, alternatives he outlined? Why couldn't you have done any of those rather than just kick all the kids out of school? So you see how the argument actually sounded like they were open to the possibility that, maybe the state overstepped its bounds in repealing the religious exemption. This is good news, folks. And, this case has not gotten a lot of attention. I invited hundreds of Connecticut and New York media contacts to attend a press conference, and really none of them wanted to cover it. They don't want to cover this case. All this attention is on this bill that's passing. Oh, they're hailing this as a big victory for public health, and the Democrats in the legislature and all of the media in Connecticut is hailing it as a great thing this bill is passing. They're ignoring the fact that there's a lawsuit out there that could undo all of it. They could completely destroy this. And if that happens, Attorney General Tong and Public Health Commissioner Giuthani and Governor Lamont and Matt Ritter, I mean, they're not going to have anywhere to go. If the Second Circuit and then the U.S. Supreme Court says that Connecticut has to allow religious exemptions to vaccines, then they have to allow it. They have nowhere to go after that. So this is the case that should be getting a lot more attention. I'm not saying don't fight the battles in the legislature. You're doing a great job. Everybody who's doing that, standing up for your rights, you're exercising your First Amendment rights, certainly your free speech rights, and participating in the legislative and political process. That's wonderful. And you should continue to do that. But don't lose sight of the courts. Don't lose sight that there's a lawsuit right now, a few lawsuits actually, that could absolutely determine this once and for all, regardless of the makeup of the legislature, regardless of what kind of bills they pass. We have a real shot here. They asked also about the Miller v. McDonald case, which is the Amish schools case that you may be familiar with, that the Supreme Court remanded back to the very same Second Circuit just in January of this year. And it's got pretty much identical facts to the facts of our case. It's the state fined these 3 Amish community schools because they continued to allow religious exemption. In our case, the state of Connecticut tried to shut down Milford Christian's Little Eagles daycare. But in the case of the Amish schools, they just fined them, but very heavy fines, 6-figure fines. And in that case, the Supreme Court just this January remanded it back to the Second Circuit to issue a new decision consistent with or applying Mahmoud v. Taylor, this precedent I'm telling you about. Well, the Second Circuit hasn't issued its decision in that case yet. And actually, our hearing today was the first time we've heard the judges address this issue head on since that remand from in the Miller case, the Amish schools case. So they actually asked both of the attorneys arguing today is, do you think that we need to wait? Do you think we can issue a ruling for Connecticut before a ruling is issued in the New York case, in the Miller case? Is there a reason we have to wait? And then they talked about, well, why shouldn't we wait for Miller? Because that case has already been fully briefed. Well, I don't know what standards they have. I'm not going to pretend to know what the internal policies or workings are at the Second Circuit. But if the standard that they're going by, which they seem to be hinting at, well, that case is already fully briefed, maybe we should wait. If the standard is we should wait, the case that's fully briefed first should be first in line, or the case that gets a hearing first. Our case was fully briefed before theirs was. They just finished their briefs after the remand. We had already finished our briefs prior to that. So technically, we are first in line for a decision. If you're making that the test, which case is fully briefed first, technically ours was. And they may hold a hearing. They could still hold a hearing. It'll be a different panel of judges, but they could hold a hearing in the Miller case to address the remand and the new briefings. That would mean it's even later until that case is fully heard, whereas our case has been fully briefed and heard as of today. We had the hearing today. So technically, we're first in line. It's not a competition, but it's just an interesting point because people are, our attorney Atkinson joked with them when asked by one of the judges, why should why should we rule in your case first? He's like, well, plaintiffs always want to be first. And he sort of chuckled at that, the judge did. And it's true. Obviously, we want to be first. We want this decided. People in Connecticut have been waiting 5 years now, folks. All right. For those of you not in Connecticut who don't realize this, 5 years. It was April 28th, 2021 was when Governor Lamont signed that bill into law repealing religious exemption. It's been 5 years, almost exactly 5 years. In less than a week, it'll be 5 years since that religious exemption was taken away from families. California's been waiting 11 years. We have a case ongoing there too. But we don't want to wait any longer. New York's been waiting since 2019, so they've been waiting a long time too. And Maine as well, 2020, I believe. This is huge. This is a big development. Things went well today. I thought they went better for us today than they did in California last week. So all eyes on the Second Circuit right now. We will keep you updated. Follow us on socials. We the Patriots USA on Facebook, at WT Patriots USA on X, Telegram, We the Patriots USA News and Updates. We are on Instagram, TikTok, YouTube, Rumble. Subscribe to our email list at wethepatriotsusa.org. You see the website right there. And if you can, make a gift, because I can't tell you, most of you should know litigation's expensive. We spent many, many, many thousands of dollars on this litigation over the years, trying to get these cases to the Supreme Court, trying to win not only for Connecticut, but for the whole country. And we've exhausted most of those resources, which is why we have a Mission 250 fundraiser going on right now to raise $250,000 by our nation's 250th birthday on July 4th. That's really important because we still have more litigation to file. We don't just do vaccine cases. We have medical kidnapping cases, kids being taken away from their parents simply because they made a different medical decision for their child. They want to opt for an alternative medical treatment or alternative medicine. Maybe in some cases, we've had a case in Connecticut, actually, where a mother tried to decline a vaccine, just wanted to decline a vaccine for her newborn. And DCF was called, wanted to do a home visit, investigation and everything. These things happen. So we do medical kidnapping cases as well. Parental rights, free speech, religious liberty, health freedom. We fight for all of those things. So check us out at wethepatriotsusa.org. Consider supporting that Mission 250 fund. And at this point, if you have any questions, any other questions about the oral argument, like I said, I'm going to post it so you guys can actually hear it for yourselves. But I know you people are asking me for reactions since I am an attorney. They're asking for my reaction after listening to it. So that my reaction is that it went quite well. I'm not going to guarantee a victory by any means. Victories are very hard to come by in this area of law, but I think it went as well as it could have gone. And the judges were open to the idea of applying Mahmoud and possibly applying strict scrutiny. They didn't say they were definitely going to, but they seemed open to considering that. And that's a good sign, because that completely changes the legal test, the legal standard, and it gives us a much, much better chance of winning. So I'm seeing some comments or questions coming in. Janelle, I did address this right at the beginning of the broadcast. You might not have heard it. When will they make a decision? We don't know. There's no specific deadline that, like, for instance, like 30 or 60 days, they have to issue a decision. No, there's no deadline. The Second Circuit can take their time. They could issue a decision in a couple of months. It could be 6 months, 7 months. I mean, they're allowed to hold this. They could wait till after the Amish case in New York is decided, the Miller case. They hinted that maybe they should do that, or at least asked us, hey, should we do that? Do we have to issue a decision right now? Should we wait? They asked the attorneys arguing today. So I can't give you an exact definitive date of when a decision will come out. It could be very soon. It could be, I don't think it'll be any sooner than a couple of months. I don't think it'll be before June, but it could be as late as September, October. I hate to say that because I know people don't want to wait 6 months, but I've seen them, wait 6 months before issuing decisions or longer. So I can't guarantee we're going to get an immediate decision, but we need to prepare, because if we don't get a decision in our favor, we've got to file immediately to the Supreme Court. And even if we get a decision that is in our favor, even if we win at the Second Circuit, don't think for a moment the state is not going to appeal this to the Supreme Court. The state isn't going to just give up the fight. They're going to want the Supreme Court to take this up. So one way or another, there's a very good chance this case could reach the Supreme Court, especially this is such a hot button issue, especially in light of recent precedent in Mahmoud, and then the Miller case just recently getting sent back by the Supreme Court. Supreme Court's watching this very closely. They know what's going on here. They're aware of it. And I think there's a really good chance we end up there. So regardless of what happens at the Second Circuit, we have a long road ahead of us to get to the Supreme Court, to argue there, and to win a case at the Supreme Court. Please help us do that by supporting us, making a donation. Pray for us and tell everyone you know about us, because the media is suppressing this. Like I said, I sent this to hundreds of press contacts for them to cover this, and not a one, as far as I know, showed up today to cover this at the courthouse. They were all aware of it. They were given the address. They were given the exact time of the hearing, the time of the press conference. They were given links, information. I sent emails to hundreds of press contacts. Every major and small independent media outlet in Connecticut, pretty much, that I had on my contacts list anyway, which is a lot, hundreds, and also many in New York, and nobody showed up. So that's disappointing. They're suppressing this. They don't want you to know that this is going on. Joshua, All right, that's not on point. Is there anyone else who has a comment or question? I'm happy to answer questions. I wanted to keep this brief. We're already at about 20 minutes. Does anyone else have any questions about what happened? Again, this is not the case. People are confusing it with the Spillane case, which is the state court case. This is not the state court case that involved RFRA that Attorney General Tong then asked the legislature to amend RFRA in HB 5044 so they could win the lawsuit. That's a state lawsuit. Our case is a federal lawsuit, but the federal lawsuit arguably is stronger because of the fact that even if that the Connecticut legislature can change the law to get around the state lawsuit, or at least they have a very good chance of getting that mooted, they can't get around the federal lawsuit. If they lose in federal court, if they lose at the Supreme Court, they lose on U.S. constitutional grounds, they can't write a law to override the Constitution. This is our best chance of a permanent victory here. I'm not saying, obviously, we still want a victory in the state court cases too. We the Patriots USA also has a state court case that asserts a RFRA claim. We have a state court and a federal court case ongoing, but I think the federal court would give a permanent and lasting victory. If we get a win in federal court, that's going to be it. They can't come back. I don't care how many of them get reelected. I don't care how many Democrats are in the legislature. They're not going to be able to get around the U.S. Constitution and the U.S. Supreme Court. They're done. They're absolutely done at that point. So I'm not saying put all of your eggs in this basket. Still get involved in the legislative process, political process, everything that you do. But there's a lot of eggs that should be in this federal court basket because this stops them dead in their tracks. And I don't think enough people understand that. And it's why we haven't gotten quite the coverage and support, because the media knows. The media knows that. The media knows, the people, and certainly the Democrats in the legislature who are proponents of this bill, this session, these several bills that they've put forth this session, they know that would be the death knell for everything they're trying to do. If they lose this in the Supreme Court, they're done. There's nowhere else to go. So they don't really want you supporting us. They don't really want you supporting federal litigation or any kind of win at the federal level, because that's very scary to them. They can get around the state level. They can make new state law, but they can't make new federal law or change the Constitution. So if there are no other comments, I'm going to wrap it up here. I don't see any other comments or questions. If you have other questions, people who watch this later after this live ends, you can post them wherever you're watching, and I'll try to go on the various platforms and answer them. Other than that, I'm going to let you go. And you can also email us too at info@wethepatriotsusa.org, or you can email me directly at Brian, BRIAN, @wethepatriotsusa.org. And I'd be happy to answer whatever questions you have. Have a good day, folks. God bless.